All right, welcome to this third and final asynchronous lecture for the class that we were meant to have on October 5th. So I think I'm going to skip right to the case of Hartman v. Hurdle. It's a quick case, and so I don't think this will be a very long lecture, but I think it's an interesting case, and let's just talk it through. And then again, happy to pick it up and talk a little bit more in class on Monday if there are questions about this case or others. So Hartman v. Hurdle, it's an old case. Dorothy Geik passed away on April 8th of 1921. She had 5 children, and she names 2 of her sons-in-law as executors of the estate. So she's got 5 children. At least 2 are daughters, right? Because she's the case refers to sons-in-law. And unclear, maybe it was a gender thing, we don't know. But she names the sons-in-law as executors of the estate. Maybe she didn't want to name her daughters. It's unclear why. It's an old case, so it's possible that there's some gender issues going on. The executors were instructed to sell her property and divide the proceeds among the 5 children. So 5 children, we know at least 2 are daughters. They're married to her sons-in-law. She names those 2 sons-in-law as executors. They are then instructed to sell the property and divide the proceeds among the 5 children equally. So on February 9th of 1922, the executors sold at least part of the real estate, the farm, that part of it, at a public auction for $3,900. However, when they made the sale, they sold to one of Dorothea's sons, whose name was Louis, right? So we know that Dorothea has these 5 children. 2 of them are daughters. Their husbands are the executors. There is then at least one son named Louis, and Louis was the purchaser of the farm for $3,900. However, the case tells us what? It tells us that when Louis bought, he was actually buying on behalf of his sister Josephine, who was married to one of the 2 executors, right? So you can easily, if you have trouble keeping this straight in your head, just make a diagram on a piece of paper with Dorothea at the top, 5 children underneath, 2 daughters who both have husbands who are the executors, and then 3 other kids. They then sell to one of the sons, Louis, but it becomes clear that he's buying on behalf of one of the 2 daughters, right, the one named Josephine, who's married to one of the 2 executors. Now, of course, we can ask, why didn't Josephine just make the purchase herself? Right? Why didn't she just buy the property at the public auction instead of Louis buying it on her behalf? And presumably, the reason for that is that if her husband is one of the 2 executors, then that would look like a very serious conflict of interest, right? It would look like the executor is essentially buying for his own account, right? And we're now far enough along in the course that you see that these executors are like trustees. They owe fiduciary duties to all of the 5 siblings. And obviously, if you're the executor and then you're buying, right, you want to buy, and you're buying for yourself, you want to buy at the lowest possible price, but the siblings want to sell at the highest possible price, a clear conflict of interest on behalf of the executor. So the executor could not buy, right, on his own behalf. And Josephine, because she's married to the executor, couldn't buy, right, because she's got the same conflict that her husband has. So to get around this, the case tells us that, in fact, it was Louis, one of the other siblings, one of the brothers, who actually purchased, but we know that he was actually buying on behalf of his sister Josephine, who was married to one of the 2 executors. Okay, so that's the setup for the facts. 2 months later, Josephine sells the property to someone named Mike Contra for $5,500, right? So bought for $3,900, sold for $55,000, very significant profit in a short period of time, and it's a lot of money, right? This is back in prior to 1922, so it might not look like a lot, but in today's dollars, these are very significant sums. So Josephine sells the property to Mike Contra for $5,500. Shortly after that, the plaintiff voices her dissatisfaction with what occurred. She's got essentially one claim, which should be clear, right? The sale of the farm to Josephine Dieker, the wife of one of the executors, was illegal and void and must be set aside. And if that's not possible, because the farm was already resold to an innocent third party, then the plaintiff should be paid 1/5 of the profits that Josephine realized on the sale, right? So Josephine's sale and any profits were illegitimate. There are 5 siblings. So if indeed she made any profits on this, which we know she did, then she should not be able to keep those profits for herself. Rather, she should have to divide those among the 5 siblings. So sure, she could keep 1/5 of the profits, but 1/5 have to be paid to each of the siblings, and that means the plaintiff is entitled to 1/5 of the profits that Josephine realized on the sale. The plaintiff is right. The plaintiff is correct here. A trustee cannot purchase essentially from himself or herself at his own sale or her own sale, and substituting a spouse does not matter unless a court gives explicit permission for this kind of conduct. So this purchase was completely illegitimate, right? And the fact that Lewis bought this when we know that it was on behalf of his sister also does not save the day, right? Because he didn't buy it for himself, he bought it for her. She couldn't buy it, and so he could not buy it and just hand it over to his sister Josephine. So the plaintiff is right. However, the property is now owned by this person, Contra, Mike Contra. Since the property is owned by Contra, Josephine will have to essentially account to the plaintiff for 1/5 of the profits that were made, right? And that's exactly what we said a minute ago, and that's exactly what she has to do. So Mike Contra doesn't have to reverse the sale, but it is the case that 1/5 of the profits will have to go back to each of the siblings, including the plaintiff in the case. So that's it. I'm not going to talk about the other case that we had for today. That concludes the 3rd segment of these asynchronous lectures, and see you all in class on Monday. Have a good weekend.